The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everybody. My name is Nathan Darris. I'm with the Texas Department of Housing and Community Affairs. We're going to get started at about 2:05 today. And so while we're wait for people to get on and take care of any technical problems that may occur, we will be putting up a short poll here. If you could go ahead and answer the question as best you can. Before we do that, I do want to give a quick bit of housekeeping. We are using GoToWebinar today, and we will be answering questions probably mostly at the end of the webinar. If you have questions, go ahead and put those into the questions box in the GoToWebinar platform. Also, to make sure that you are having the best audio experience you can go ahead and open up the audio tab and use the sound check option. And so, like I said, we're going to get started at about 2:05, and I will be putting up the poll. So we will see you in just a few minutes.
Okay, good afternoon, everyone. Welcome, everyone, and thank you for joining us for TDHCA's next topic in our Fair Housing Month webinar series. Today, we will be talking about the Violence Against Women Act, or VAWA, and how it applies to TDHCA programs. A quick disclaimer before we get started, TDHCA is a recipient of HUD Fair Housing Grant for education and outreach activities and initiatives. Today's presentation has been developed in support of this grant, with support from this grant. So as a quick disclaimer, the things that we're presenting today do not necessarily represent the views of HUD. Before we get started, I have a few housekeeping reminders. All materials and a recording of this webinar will be available on the TDHCA website. If you have any questions, please enter them into the questions box. If we see questions coming in on a certain topic, we'll try to answer those as we go. However, we'll try to get to the bulk of questions at the end of the webinar. So again, please enter those into the questions box in the GoToWebinar panel. The training presented today is just informational only. We're not going to be giving a test or issuing certificates at the conclusion of this webinar. This is for information purposes only as part of our celebration of Fair Housing Month in Texas in April. So if you're looking to meet the requirements for some of our post-bond closing documentation or 10% test training requirements, this is not the webinar for you. This is, again, just for informational purposes only, and we're not going to do certificates at the end. So let's get started. I'm Kate Trace. I'm the manager of Fair Housing at TDHCA. Joining me today for our presentation is Nathan Darris. We'll be switching off on the material, so I'll start, and then Nathan will join us a little bit later. Nathan is our fair housing specialist at the department. If you've reached out to us for training or technical assistance or help in putting together some of your plans that revolve around fair housing, you've likely talked to one or both of us at some point. So welcome, and we're happy to have you here today. So today, we're going to talk about the following things. We'll go over what the Violence Against Women Act, Reauthorization Act is, the HUD guidance based on this act, and then required notification as a TDHCA administrator or an administrator of HUD funding, how you document individuals or households that are covered under VAWA, and then Nathan will give an overview of lease bifurcations and emergency transfer plans before we get to the questions section. So hopefully, by the end of the webinar today, we really hope to increase your understanding of VAWA and its purpose, your roles and responsibilities as a housing provider, or someone else that, someone that lives in a covered property. We also hope that you're able to know about the required notifications and documentations that are required under VAWA, and then have a better understanding of how to do a lease bifurcation and an emergency transfer plan. So before we get started, I have another quick disclaimer. In today's training, we will be covering the sensitive topics of domestic violence and sexual assault. Understandably, these topics are difficult to listen to for some, and we recognize that some may feel uncomfortable or sensitive to the subject. The language in the regulations to describe the population covered by this rule uses the word victim, but that word has fallen out into disfavor, and so during this training, we are going to use the word or the phrase covered person or covered persons. So covered persons refers to those that are covered under the Violence Against Women Act, or VAWA. Again, we'll try to cover any questions that you have. We recognize that some questions may be specific to a certain case, and may actually need legal advice. So please note that Nathan and I are not attorneys, but we will do our best to address any questions within our scope. So at this point, I'm going to hand it over to Nathan, and he is going to talk about the Fair Housing Act. Nathan?
Thank you, Kate. So far this month, we have mostly talked about the Fair Housing Act, both the federal and Texas Fair Housing Acts. The Fair Housing Act is the policy of the United States to provide within constitutional limitations for fair housing throughout the United States. No person shall be subjected to discrimination because of their race, color, religion, sex, disability, familial status, or national origin in the sale, rental, or advertising of dwellings, or in the provision of brokerage services, or in the availability of real estate-related transactions. The Violence Against Women Act provides protections for persons that have been subject to domestic violence, dating violence, sexual assault, or stalking. VAWA protections are a change or an exception to a standard policy or procedure to accommodate a household that is otherwise eligible for the housing-related program and has experienced domestic violence, dating violence, sexual assault, or stalking. VAWA protections are available equally to all individuals regardless of sex, gender identity, or sexual orientation. VAWA originated and was signed into law in 1994 and has been reauthorized by Congress in 2000, 2005, and 2013. The reauthorization in 2013 expanded the law by including protections for American Indians, same-sex couples, and increasing protections for victims of sex trafficking, and covered some additional housing programs. As Kate mentioned, the language of the Act includes the term victim when referring to persons who have experienced domestic violence, dating violence, sexual assault, or stalking. During today's webinar, we will be using the term covered person or covered persons when applicable. In March of 2021, the U.S. House of Representatives voted to reauthorize the Violence Against Women Act, although the Senate has not yet done the same. Even though VAWA has not yet been reauthorized, the protections that it affords still exist and are still in effect. HUD published its VAWA final rule implementing the requirements of VAWA 2013 on November 16, 2016. The notice included the following changes for the HUD multifamily housing programs. It specified sexual assault as a crime covered by VAWA in HUD-covered programs. It established new requirements for notification of occupancy rights under VAWA, specifically Form 5380. It establishes requirements for creating an emergency transfer plan, and Kate is going to talk about those required forms later in the training, and I'll be covering more about emergency transfer plans after that. Many survivors of domestic violence who are living in or near the poverty line are often forced to choose between staying in abusive relationships or becoming homeless. For many survivors, concerns over their ability to provide housing for themselves or their children are a significant reason for staying in or returning to an abusive relationship. Access to resources that increase economic stability are essential to rebuilding life after abuse. Housing is a constant need for survivors of domestic violence. This table shows the total number of victims of domestic violence in Texas in calendar year 2019. It must be noted that there is not a one-for-one relationship between incidents and victims of domestic violence. One incident can involve multiple victims, and one victim can experience multiple incidents. Additionally, according to the Texas Council on Family Violence's 2019 state plan, Texas's network of Health and Human Services funded programs served 71,500 survivors of domestic and family violence in 2018. So here are some definitions that are going to be important to understanding VAWA and will be important in the rest of this webinar. Sexual assault is any non-consensual sexual act prohibited by law or sexual offense that meets the definition of rape, fondling, incest, or statutory rape. Sex offense is defined as any sexual act directed against another person without the consent of the victim, including instances where the victim is incapable of giving consent. For the purposes of this definition, consent means voluntary, positive agreement between the participants to engage in specific sexual activity. Domestic violence is defined as any felony or misdemeanor crimes of violence committed by a current or former spouse or intimate partner with whom the victim shares, a child, person, or a person who has cohabitated with the victim, a person in violation of any other state or local domestic and family violence laws. This means that even if none of those first three bullets apply, the act may be covered by a state or local law. The National Domestic Violence Hotline defines domestic violence to be a pattern of behaviors used by one partner to maintain power and control over another partner in an intimate relationship. Domestic violence is not only physical, it can be emotional, verbal, or financial. Dating violence is violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. The existence of such a relationship shall be determined based upon the reporting party's statement and with consideration of the length of the relationship, the type of relationship, and the frequency of interaction between the persons involved in the relationship. For the purposes of this definition, dating violence includes, but is not limited to, sexual or physical abuse or the threat of such abuse. Dating violence, however, does not include acts that are covered under the definition of domestic violence as defined previously. Stalking is any conduct directed toward a specific person that would cause a reasonable person to fear for safety or suffer substantial distress. For the purposes of this definition, substantial distress means significant mental suffering or anguish that may, but does not necessarily require, medical or other professional treatment or counseling. Similar to reasonable accommodations under the Fair Housing Act, VAWA protections are a change or exception to standard policies and procedures to accommodate a household that is otherwise eligible for the program and has experienced domestic violence, dating violence, sexual assault, or stalking. Unlike under the Fair Housing Act, VAWA protections, including lease bifurcation, do not apply to guests or unreported members of a household or anyone living in a unit who is not a tenant. Being a victim of domestic violence, dating violence, sexual assault, or stalking is not a basis for denial for assistance or admission to assisted housing if the applicant otherwise qualifies for assistance or admission. For example, if a housing provider has adopted written standards to prioritize rental assistance for applicants with good rental history, an exception to written standards could be made if the rental history is related to violence as documented on the forms that we'll cover later in this presentation. A history of evictions, criminal activity, or poor credit directly related to the victimhood of domestic violence, dating violence, sexual assault, or stalking are not cause for termination of assistance. These are examples of adverse factors from experiencing domestic violence or sexual assault. So what's an adverse factor? An adverse factor is any factor that can be used as a basis for denying admission or assistance into a housing program, terminating assistance or participation in a housing program, or eviction. Housing providers may have to determine whether an adverse factor is a direct result of domestic violence, dating violence, sexual assault, or stalking. However, if a denial or termination is required by a federal statute based on a particular adverse factor, the housing provider must still deny or evict the applicant or tenant. An example of this is the Section 811 Project Rental Assistance Program. If an applicant is subject to a lifetime registration requirement as a sex offender, the applicant is ineligible for admission even if their offense was a result of them being a victim of domestic violence, dating violence, sexual assault, or stalking. An applicant or tenant should inform the housing provider that they are a covered person and provide information or documentation to support the assertion that the adverse factor is a result of domestic violence, dating violence, sexual assault, or stalking. The housing provider may ask for additional information or clarification in order to objectively determine if the adverse factor is a result of the applicant or tenant being a covered person. So we've talked about what VAWA protections are under the Act and examples of adverse factors. So what does this mean in practice? Having experienced domestic violence, dating violence, sexual assault, or stalking is not a basis for denial of assistance or admission to assisted housing if the applicant otherwise qualifies for assistance or admission. Incidents or threats of domestic violence or stalking will not be construed as serious or repeated violations of the lease or as good cause for termination of assistance, tenancy, or occupancy rights of a covered person. As a housing provider, it is your responsibility to provide a safe property for tenants and program participants. As housing providers are charged by law to uphold protections for victims of domestic violence, dating violence, sexual assault, and stalking. It is very difficult for someone to self-identify as having experienced violence. VAWA protections are provided when a tenant or applicant self-identifies or is identified by a third party on their behalf. As a housing provider, your job is to follow the rights and protections under VAWA and provide documentation and have resources readily available to assist these covered persons. Since the beginning of the coronavirus pandemic, domestic violence hotlines and shelters have seen an increase in calls and check-ins because people were forced to quarantine with their abusive partners and/or family members. The National Domestic Violence Hotline alone reported a 9% increase in contacts over this time. This might be a good place to see if we have any questions that have come in yet.
Hi, Nathan. Thank you. This is Kate Trace again. We don't have any questions that are specific to the material. We were just helping some folks get their audio up and running. And we did have one question about the slides. The slides from this presentation will be available after the webinar. They'll be posted on the TDHCA website, and we will send out a link about where to access the slides and all of the other information. So again, if you have questions on the material that we're covering, please enter them in the questions box and we'll do our best to answer them.
Great.
So I will continue with the presentation here. Get to the next slide. Thank you. So we've talked about who is protected under VAWA, but what programs does VAWA apply to? The latest reauthorized version of VAWA is divided into 12 titles. The provisions in Title VI, which is titled Safe Homes for Victims of Domestic Violence, Dating Violence, Sexual Assault, and Stalking, protects victims from denial of admission, denial of assistance, termination of assistance, or termination of tenancy if the applicant otherwise qualifies for assistance or admission. The VAWA Title VI provisions are applicable to all HUD programs, many of which are administered in statewide programs in Texas by TDHCA. Additionally, the VAWA Title VI provisions apply to rural housing, which is covered by USDA, and the Low-Income Housing Tax Credit Program, which is regulated by the IRS and administered in Texas by TDHCA. So on this slide, here's a list of the programs that are covered by VAWA. The list includes single-family programs such as ESG, or the Emergency Solutions Grants Program, and Home Single Family. It includes multifamily programs such as the Low-Income Housing Tax Credit Program and all of the programs that are in the umbrella of the Multifamily Direct Loan Program. So basically all of our multifamily properties. This also includes the Section 811 Project Rental Assistance Program and the Housing Choice Voucher Program, either tenant-based and project-based. So as we mentioned earlier, in 2013, HUD expanded VAWA coverage to some additional programs. This expansion included the National Housing Trust Fund program, which was newly enacted at the time and was being rolled into many other federal regulations. So in short, VAWA is applicable to all HUD-funded programs and to all TDHCA multifamily programs, regardless of the funding source. So now that we've gone over what programs are covered, we'll talk about how these requirements are reflected within TDHCA's rules. All tenants and applicants of TDHCA properties or those who receive rental assistance from Section 8, Section 811, the Home TBRA program, or ESG distributed by TDHCA, or by a TDHCA-funded organization may not be denied assistance, terminated from participation, or be evicted from their rental housing because they have been subject to domestic violence, dating violence, sexual assault, or stalking. So if any household member has been subject to domestic violence, dating violence, sexual assault, or stalking by another member of the household or by any guest, the household member may not be denied rental assistance or occupancy right under a TDHCA program solely on the basis of criminal activity directly related to that domestic violence, dating violence, sexual assault, or stalking. An affiliated individual can mean a spouse, a parent, a brother, a sister, a child, or a person to whom you stand in the place of as a parent or a guardian. For example, the affiliated individual is in your care or your custody. Or it could be an individual, a tenant, or a lawful occupant living in your household. So these are the forms that TDHCA requires that housing providers have available and distribute to applicants and tenants. These forms are available on the compliance form section of the TDHCA website. They're also available in the handouts. So there's a whole packet of handouts that are available for this presentation. So the first required form is TDHCA's Notice of Occupancy Rights under VAWA. So this is a form that TDHCA has modified based on HUD Form 5380. On the TDHCA website, it is available in a downloadable, fillable form, a Word document, in English, Spanish, and Vietnamese. The other form is called the Certification of Domestic Violence, Dating Violence, Sexual Assault, or Stalking, and Alternate Documentation. This is the HUD 5382. So you'll hear Nathan and I refer to these forms in the next few slides. This form is available on the TDHCA website as a downloadable Word document in English and Spanish. And then HUD has provided this form on their website in several languages. So again, you can download this from the handouts and on the TDHCA forms compliance webpage. It's important that these forms are available in the leasing office or anywhere else a housing provider would take applications, and that includes on a property's website if you accept applications electronically. So the housing provider must provide these TDHCA forms, both the TDHCA form based on the HUD 5380 and the HUD 5382 to all applicants or tenants at all of the following times. I know this seems like a lot of notification, but this is the HUD requirement and in turn the TDHCA requirement. So these are all of the times when you have to provide both of these forms to the applicant or the tenant. At application, regardless of the approval or denial status, when a household signs their lease agreement, when a household receives any type of notification of eviction, termination of assistance or non-renewal, and during any annual recertification or lease renewal process. If there's no annual recertification or lease renewal within 12 months, the documents still must be provided within that 12-month time frame. The documents must also be provided with any notice of eviction, whether it's material noncompliance or criminal activity, or any notice of termination of assistance, whether it's a failure to respond to recertification or a failure to move into a different size unit or an increase in income. Whatever that is, you do have to provide these two forms to the applicant or the household. Let me just get my notes. I've got a couple of more things to say about this slide. Well, it's not optional to provide all of these forms to the tenants and the applicants. It is optional that they complete these forms. The HUD form 5382 should be completed by the applicant if the applicant or the program participants are seeking VAWA protection. So just because you give these out does not mean that they have to be completed and returned. These are just an option for the applicants or the tenants if they need these protections. They have the information and they have the form to complete if they need and provide back to the housing provider. So individuals affected by domestic violence may be discouraged from applying for housing if they're unaware of their rights. So providing these VAWA forms at application and non-renewal termination ensures that applicants are aware of their rights. So also by normalizing handing out and receiving these forms, covered persons would be more likely to know what their rights are and what their protections are under VAWA. So this may be when the housing provider provide these forms, they might be the only time that a covered person would understand what their rights are under VAWA. So as a housing provider, you are providing a very important service for someone that might need these the protections under VAWA. Okay, so in the next few slides, I'm going to talk about some of the specific rules as it relates to the TDHCA programs. So in the department's Texas Administrative Code rules for the homelessness programs, subrecipients of emergency solutions funds must inform denied applicants or their program participants whose participation has been terminated of rights that they may have under VAWA. And they may not deny admission to applicants solely based on their status as a covered person under VAWA. It's important to note that in the ESG rules, safety planning for covered persons under VAWA is an allowable case management cost if you're an ESG subrecipient. So you can use some of your case management funds for safety planning. And we do recognize that in the Emergency Solutions Grants Program, there may be some separate requirements for providers of domestic violence services. This presentation is only about ESG subrecipients as a whole. So if you have specific questions, please contact the ESG staff at TDHCA. If you don't know who to contact and you are a recipient of the ESG funds from us, just reach out to Nathan or I and we will connect you with the correct staff member. But again, if you have any questions, please reach out to us and we can help either get you an answer or find you the right person to talk to. So next I'll talk about, in our single family programs, the Home Tenant-Based Rental Assistance Program. So again, VAWA forms must be provided at application and before termination. Now this is a different requirement, a more specific requirement for the Home TBRA program. Home TBRA administrators must notify the department within 3 days when a tenant submits that form, the certification of domestic violence, dating violence, sexual assault, or stalking, or any other alternate type of documentation. And I'll talk about alternate documentation in a few slides. So you have to notify the department in 3 days if someone provides this form to you or alternate documentation. And then the housing provider or the TBRA administrator must also submit a plan to the department for continuation or termination of assistance to the affected household member. So again, if you're a TBRA home administrator and you receive this form, reach out to us as soon as possible or within 3 days and let us know your plan about how you are going to assist this household. And just a little administrative note, these Texas Administrative Code rules were recently renumbered. So the citation number is new, but this is not a new requirement. Okay, next I'm going to talk about the Section 811 Project Rental Assistance Program. So if you're a Section 811 participating property, please be aware that the requirements to provide all of these VAWA forms, they appear both in the TAC rules that cover the uniform multifamily programs, and then they also appear in your specific section of the rules just for the Section 811 program. So the rules appear in two places, and that is intentional. So it applies to all multifamily programs, and it also applies specifically to the Section 811 program. I think the program staff has done a good job of consolidating all of the rules for Section 811 in one area. Again, if you have questions about this type of documentation, if you're a Section 811 participating property, please reach out directly to the staff of that program. If you need assistance in connecting to that staff, please reach out to Nathan or myself and we will connect you right away. But I'm sure that you know who to contact here. So, okay, moving right along. So we've talked about what forms you need to provide. We've talked about the acts. Now we're going to talk about when you receive this documentation, what do you do? Okay. So if a tenant or an applicant has identified themselves as a covered person who has experienced domestic violence, dating violence, sexual assault, or stalking, the housing provider may request in writing one of the following. And note that I said may, not shall here. So this is a list of or statements. You can request either the completed HUD 5382 form. You can request a signed certification by a victim service provider, an attorney, a medical or health professional from whom the covered person sought assistance. You could request a record of a federal, state, tribal, territorial, or local law enforcement agency, court, or administrative agency. Or you can request a statement or other evidence provided by the applicant or tenant. And this last bullet would be at the discretion of the housing provider. The housing provider may also accept verbal requests for VAWA protection. So although you may request these things in writing, you still have to accept verbal requests for VAWA protections. If you do receive a verbal request for protections, please document that, that you did receive that. And a little bit later in the slides, I will talk about confidentiality and the extreme importance of confidentiality for covered persons with VAWA protections. So again, you can accept in writing and you can accept verbal requests for VAWA protections. Per the HUD guidance, the housing provider may not require more than one type of documentation. The housing provider may request a response within 14 business days, or you can extend that time period at your discretion. But please at least give the person that is seeking VAWA protections at least 14 days to provide this documentation to you. I think 14 days is a good benchmark, even though that is a HUD guidance number. I think it gives enough of an opportunity for someone that might have a schedule where they work over the weekends, or it gives enough time for them to collect this information from a doctor's office that might not be open when they have access to go to the doctor's office. So it gives them enough time to collect this information. If no documentation is presented, or if the applicant or tenant fails to present the information on time, as the housing provider, you do have the right to deny the VAWA protections to the applicant or the tenant. If the housing provider is given two conflicting forms, you can again ask for some third-party documentation that would help reconcile those two conflicting forms. Okay. So all of the information and all of the documentation received must be maintained with very strict confidentiality. No one should have access to this information unless it is absolutely necessary. Any VAWA-related information should not be provided to other employers or contractors unless it's required by law. The VAWA information should not be entered into a database or provided to others without consent from the covered person, or unless it's required for an eviction action by law. So it's important that you secure all correspondence and personal interaction with the covered person to maintain their confidentiality. And then please document that covered person's preferred method of communication within their tenant file, either if they want to be contacted by email, by phone, by text, or in person only. And the covered person does have the right to designate an attorney or an advocate or another secure contact for communications. So again, keep all of the documentation separate and out of their tenant file in a separate secure location, but you can note in the tenant file how this person would prefer to be contacted. Okay. Again, I'm going to say it again. I know you have all absorbed this information, but it is very important to keep VAWA communication separate from a tenant file. So if someone comes to you with a verbal request and you make a note, this tenant has requested VAWA protections, do not put that note in the tenant file. Keep it in a separate, secure, locked file away from the tenant files. It is very important to protect the identity and the safety of individuals or households covered under VAWA protections. Okay. So in the case where you might get conflicting evidence, where perhaps there's more than one party within a dispute that can claim covered person status from the same incident of domestic violence, dating violence, sexual assault, or stalking, the housing provider may request documentation from the second party that may contradict the initial information provided by the first party. So you've got two individuals, for example, that are involved in a domestic violence incident. They both request covered person status, but they provide conflicting information. You can request additional information from both parties, and you must allow 30 days of a response time to provide this information. This is a must. So the HUD guidance says if you have conflicting evidence, please allow both parties 30 days to provide a response. 30 days may be if they need, legal documentation, or if there is a police report or something else. It may take an additional amount of time beyond that original 14-day time frame. So this 30 days is really important to help cure any conflicting evidence. If it's available within your company or your organization's resources, please seek legal guidance regarding potentially conflicting evidence and a proper course of action. I know presenting this in a couple of slides in a presentation, I can just read it off and say, go do this. It's very tricky in real life situations. If you have the resources, please contact and seek legal guidance. Nathan and I are not attorneys. We've said this before. We're just trying to provide some information that would be helpful if you receive documentation for a VAWA covered person. So again, please seek the advice of an attorney. Okay. So let's talk about eviction. A tenant can be evicted or their assistance can be terminated for serious or repeated lease violations that are not related to domestic violence, dating violence, sexual assault, or stalking. Tenants who are victims of these covered events, the domestic violence, dating violence, sexual assault, or stalking, cannot be held to a more stringent set of rules than any other tenant. So VAWA protections may not apply to a tenant if you, as their housing provider, can demonstrate that not evicting this tenant would present a real and physical danger that both would occur within an immediate time frame and could result in the death or serious bodily harm to other tenants or those who work on the property. If the housing provider can demonstrate either one of those two things, then the housing provider should only terminate assistance or evict the tenants if there are no other actions that can be taken to reduce or eliminate this threat. This information is all included in TDHCA's form based on HUD's Notice of Occupancy Rights under VAWA. That's the Form 5380. All of this is in there. Again, it is in your handouts and it is posted on the compliance form section of the TDHCA website. If you're unable to access the handouts from this presentation, we will send links out to all where you can download and access all of this information following the webinar. Okay, I have talked a lot, so I'm going to hand this over to Nathan to finish us up. And Nathan is going to start with lease bifurcation. Nathan.
Thank you, Kate. So what is lease bifurcation? Bifurcating a lease creates two leases for the same unit. One lease is for the perpetrator and one is for the covered person. The housing provider can then evict the perpetrator without evicting the covered person. So whenever the housing provider removes a household member from a lease to evict them, they are terminating that household member's occupancy rights and their assistance. Housing providers should follow their standard grievance or appeal procedures and family breakup policies. In some jurisdictions, partial or single tenant lease terminations may be disallowed by law. In those cases, HUD suggests that the housing provider attempt to nullify the original lease and then enter into a new lease with the covered person. In other circumstances, when safe, HUD also recommends attempting to reach an agreement to the mutual termination of the lease. TDHCA, in these instances, recommends consulting your legal counsel to make sure of the proper steps for your particular program. HUD recommends that housing providers do allow 90 calendar days after the lease bifurcation in order to establish eligibility for that same housing program, or to establish eligibility in another covered housing program, or to find alternative housing. This time frame can vary by program regulations, and housing providers should consult the rules for their programs that they participate in for specific time frames and requirements. We're going to jump over to emergency transfer plans now. The emergency transfer plan is what housing providers need to follow when conducting an emergency transfer. The plan states how a housing provider will identify tenants who are eligible for emergency transfer, the documentation needed to request an emergency transfer, confidentiality protections, how an emergency transfer may occur, and guidance to tenants on safety and security. The HUD Form 5381 is the Model Emergency Transfer Plan. This form is available in the handouts for today's webinar and is also available on the TDHCA website along with all of the other compliance forms that we've discussed so far. The HUD Form 5383 is the Emergency Transfer Request Form that a housing provider must give to tenants who would like to complete a request. Both forms indicate that they expired in 2017, but please note that these are the most recent forms available and they are acceptable for use. HUD guidance additionally requires housing providers to have an emergency transfer plan. HUD supplies the Form 5381 as a model transfer plan. TDHCA additionally provides a version of the HUD 5381. The TDHCA version is available in the handouts and on the compliance forms page that we previously listed. If a housing provider is a participant in TDHCA's Section 811 program, the housing provider must adopt the department's specifically required emergency transfer plan for that program. Upon request from a covered person, the housing provider may permit the covered person to move to another unit, subject to availability, and to still keep their assistance. In order to approve a request, the housing provider may ask the covered person to provide documentation that the covered person is requesting to move because of an incident of domestic violence, dating violence, sexual assault, or stalking. If the request is for emergency transfer, the housing provider may ask covered persons to submit a written request or fill out a form where they certify that they meet the criteria for an emergency transfer under VAWA. These criteria are: the covered person is a victim of domestic violence, dating violence, sexual assault, or stalking. If the housing provider does not already have documentation of this, they may ask the covered person to provide this documentation. 2, the covered person expressly requests the emergency transfer. The housing provider may choose to require the covered person submit a form or may accept another written or oral request for this. And 3rd, a covered person reasonably believes that they are threatened with imminent harm from further violence if they remain in their current unit. All of this has there's an extra criteria here. If the covered person has been subjected to sexual assault, then in addition to qualifying for an emergency transfer because they reasonably believe they are threatened with imminent harm from further violence if they remain in their unit, the covered person may qualify for an emergency transfer if the sexual assault occurred on the premises of the property from which they are seeking their transfer and that assault happened within 90 calendar days before the transfer was requested. The emergency transfer plan must describe policies for assisting a tenant in making an internal emergency transfer when a safe unit is not immediately available, and must describe reasonable efforts the housing provider will take to assist a tenant who wishes to make an external emergency transfer when a unit that meets the victim's safety standards is not available. Remember, the victim is the only person who determines whether a unit is safe. In developing the emergency transfer plans, housing providers should examine their waitlist policies and tenant selection criteria to determine if any changes need to be made to facilitate emergency transfers. Some things to consider here might be the availability and location of units at your property, the demand by applicants for assistance, how long is the wait list, for example, frequency of internal transfer requests, and the ability of alternative housing opportunities. For more detail on this, see Section 12 of the HUD Notice H2017-05, which is in the handouts for today's webinar. HUD requires that all requests and their outcomes for emergency transfers must be reported to HUD annually. As a recipient of HUD funds, TDHCA has a responsibility to report data to HUD in a consolidated annual report. TDHCA collects this information from the compliance department. This includes 1, the number of emergency transfer requests received, 2, the number of requests resolved, 3, the number of requests that are still pending, 4, the outcomes of requests, and those outcomes include the following data points: number of internal unit transfers within the same project, the number of requesters relocated to other HUD-funded housing sites, the number of other move-outs, and finally, the number of requesters who choose to remain in the unit. This information needs to be provided to compliance each time a transfer request has been made. You can send these data points to vawa.transfer@tdhca.state.tx.us. Note that this reporting requirement only applies to properties with HUD funds. It is not applicable to housing providers that are solely funded using low-income housing tax credits. Additionally, do not send in any personally identifiable information to TDHCA when reporting the number of transfer requests and outcomes of the requests. No names or any personal information are required or desired. VAWA protections are necessary and important to ensuring the safety and well-being of victims of domestic violence, dating violence, sexual assault, and stalking. However, a victim might need additional resources outside of VAWA protections to assist them. It is also important to connect with local or specialized resources, including supportive services. Housing providers may want to consider outreach to these types of organizations in the development and review of their emergency plans. These are some of those available resources. If you have any specific fair housing training needs, you can reach out to us at any of the following methods. We are going to move into questions at this point, I think. Kate, is that, do we have questions ready?
Yes, we do. Sorry, I was just getting my mic unmuted. So we do have some questions. Nathan, when I was talking earlier, you had answered some questions directly.
Yes.
I think it might be useful to review those questions so that the general audience can get those answers as well. So
yes, yeah, I know which questions you're referring to. So
great,
I wanted to come back to them as well. So the first question was, if a property is not funded by TDHCA or HUD, can they not support VAWA protections? And the answer to that is no. You absolutely can incorporate similar protections in your rules or your policies. You can put them in your lease or your lease addendum. And as a lease addendum, VAWA is only required of HUD funded or IRS or USDA or TDHCA funded housing programs or properties. But other properties are certainly able to follow these guidelines to extend these protections, even if they don't participate in any of those programs.
Okay, could you please address the question about the housing authority? So I'll read it out if you want to give the answer.
Sure.
Does a housing authority have to provide both of the forms, the 5380 and the 5382, or just the 5380 to the housing choice voucher clients?
Right. If you are a housing authority and you receive HUD funding, which I think almost all housing authorities would, you need to provide the 5382 and the 5380 to your clients and to your tenants. And that would be at any of those 4 contact points that were mentioned earlier. So at lease signing or application, at any notice. Go ahead, Kate.
Excuse me. This is on slide 24. If you want to bring that slide back up again, we had another question to repeat when is the required notification time. So see if we can bring that up for the audience. Okay. Sorry for the interruption. You want to continue with those times?
No, that actually is great because I couldn't get them off the top of my head. So yes, as a recipient of HUD funds, including a housing authority, you need to get the 5380 and the 5382 to all applicants and program participants at the time of application acceptance or denial, prior to the execution of any rental assistance agreement, with any notification of eviction or notification of termination of assistance, or during any annual recertification or lease renewal process, whichever of those you have. And that is required of all multifamily properties. You may want to check HUD specific recommendations or requirements for housing authorities as to when those need to be given out. TDHCA does not oversee housing authorities, and so they will likely have some different requirements, but I imagine they might be fairly similar.
Great. Thank you, Nathan. We had another question about documentation. So one of the folks submitted a question saying, you know, if we need to keep someone's information secure and separate, you know, we're putting them into our database. Nathan, could you speak to the difference between your normal tenant files and your separate confidential files?
Right. So really what you want to do is, if you have a system where you have information about all of your tenants and you're keeping information in there that you would keep about any tenant, that's all fine, even if the person is covered by VAWA. But as soon as a piece of information is related to VAWA protection, so that could be any of the forms that that you require them to fill out, any of the documentation that they would need to prove that they are a covered person, that all needs to be completely separate. And I can't say for certain, I'm not an attorney, but I don't think it's a great idea to have, say, a VAWA database. I would want to treat each VAWA protection, or each incidence of VAWA protections separate from any other information about your tenant, any other tenants that you have.
Okay. Thanks, Nathan. I think that was explained really well. We did receive a question that's pretty specific to the home program. One of our attendees is a home TBRA administrator and asked about something specific in the rules that says compliance with the VAWA regulatory requirements under this section, this is citing some of the CFR code, are required for any tenant-based rental assistance or any housing project for which the date of the home funding commitment is on or after December 16th, 2016. So there is a piece of the regulations that says this does not apply to home commitments before December 16th, 2016. And my question back to this individual was, well, do you even have households or clients that still exist having these commitments on or after December 16th, 2016? This is a program-specific question that I am not able to answer. I will have to get with the home single-family staff. So if you in the audience are also a home TBRA administrator and had that question, we're going to connect with the home single-family staff and get some clarification on this and see if it can get sent out to the home administrators that may find that useful. Did you have anything to add on that, Nathan?
I was going to say that I did not expect that would be a concern. I actually removed the reference to December 16th, 2016 from the slides at one point because I did not think there could be, I really didn't think there would be any agreements that would be dated before then. But I was wrong, so we'll look into that for you.
Yeah. Thank you for that question. Let's see. Nathan, do you want to look through these questions and see if there's anything else that we could answer right away? Maybe while we're looking, you could put up the slide for our next trainings.
Yeah, let's throw that one up real quick.
Okay. So as Nathan is pulling up this slide, we do have, as part of Fair Housing Month in Texas, in the month of April, we've done a whole series of webinars in April. The last two are next week on Tuesday and Thursday. It'll be affirmative marketing and then limited English proficiency and language access plans. So I really hope you've enjoyed all of our presentations so far, and you'll be able to join us for those next two. So Nathan, did I buy you enough time to pick out a question that you'd like to answer?
Yeah, absolutely.
Okay. Fantastic.
So the question here is, how do you handle a situation where a tenant is protected under VAWA and the perpetrator was removed from the lease, but the covered person invites the same abuser, the same perpetrator back into the apartment? What do you do in this situation? The good thing is that you have removed them from the lease, which means they are not covered by the lease. They're not a tenant in the unit. So the same rules that would apply to any other unit that has an individual in it that is not a tenant, those are the rules that would apply to them. Unfortunately, we're not in the business of giving relationship advice. And if this is a person they want in their life and the person is disruptive to the rest of the property, as in presents a danger, then you need to be able, that would trigger a situation where you might, the covered person could still be evicted for any things that happen because they invited that person back into the apartment complex. So I know that that's not really a cut and dry answer, but it is going to depend upon what your on-site written policies and procedures are, and if the household is breaking those rules. Also, this is a situation where I would say consult your attorney and your compliance staff, because there is that a situation where now we're talking about a situation where I don't have all the context, we don't have all the details. So that would be an excellent situation for your attorney.
Great, thank you, Nathan. I'll take one of the next questions. Can VAWA help tenants who would normally be evicted due to having money stolen from an abusive partner? I think Nathan went over this in one of the slides. Abuse can come in the form of financial as well. It can be, it can be someone controlling funding. So certainly the VAWA could cover this person who would be evicted because money is being stolen from an abusive partner. So if this question was related to a specific tenant, definitely, like Nathan said, contact an attorney to see what the appropriate avenues would be. But, make sure that that tenant is, has received the documentation and understands their rights under VAWA. So yes, without knowing all of the specifics, VAWA would cover that person because financial control can also be an abusive situation.
To piggyback on that for just a second, something that's important to remember is that, we talk about emergency transfers and evictions and bifurcation of leases, but at the very core of it, VAWA allows you to make changes or alterations to your already existing policies and procedures. So in a situation where someone might be evicted because of non-payment of rent, that would be a situation where you can determine or try to decide whether or not you would make an accommodation to say what you determine as late payment, establishing a payment plan, or not assessing any late fees for a certain period while the person recovers from having that money stolen or that financially abusive relationship. So just remember that it is at its core an accommodation to your existing policies and procedures, and that can include parts of the lease as well. So.
Okay, great. Thank you for that follow-up, Nathan. Let's see, were there any questions that you wanted to answer? We've just got a few more in this list here. Some of them might need a more specific follow-up directly with the asker, and we will reach out to you and get a little bit more information. Did you see anything else, Nathan, in this list that we could answer publicly?
Yeah, so one of those specific ones, and it has a more general answer. So when an applicant applies for housing, is there a time frame on how recent the domestic violence or the covered event has to have been in order to be considered? So for example, if they state they are a covered person, but the incident happened, say, 6 months ago, the question is, what is the issue that makes them not qualify? And so let's say it is a criminal screening, or let's say it's a credit screening, and that poor credit or that particular criminal history that is the problem is directly related to something that happened that 6 months ago, is covered by that incident, then no, there's no time. That's the time frame. The time frame is only determined by when the incident was, and how it's connected to whatever it would otherwise cause this person to be not to not be qualified for the program.
Great, thanks, Nathan. I did just want to clarify. We had talked about within the emergency transfer plan eligibility, another time frame of if something happens at a certain point, is there a time frame that covers that person as a covered person under VAWA. So if there was a sexual assault that occurred on the premises of the property from which the person is seeking a transfer, and this is just specifically to transfers, not for applications, then if that assault happened within 90 calendar days before the transfer was requested, then that is allowable. And I don't know where the HUD regulations say if something happened beyond that 90 calendar days. That would be something that we would point you to the HUD regulations for. I'm not specifically familiar with that, but there is that 190 calendar day period preceding a request of an emergency transfer if there was a sexual assault on the property. So just a little bit of tangent for that question.
There was another 90-day as well.
Okay.
Which is and it is related to emergency transfers. And I think it may also technically apply to lease bifurcation, which is if in the process of transferring or in the process of bifurcating the lease, the protected person is no longer qualified, either whether it be an income qualification or some other qualification, but the act of that bifurcation or the act of that transfer is what causes it, then that would be a situation where they have HUD recommends a minimum of 90 days for that person to establish either qualification or to qualify for a different housing program or to find alternative housing. So, just because they're not qualified as soon as that lease gets bifurcated, then you don't initiate the eviction proceedings right then because they're not qualified. You would have to wait that 90 days before you start that eviction proceeding. But that's a forward-looking 90 days, not a backward-looking time frame.
Okay. Great, thank you for that. I do see we have a couple of more questions that are coming in that are kind of falling a little bit outside of the scope of what we discussed here in this presentation. They're really excellent questions. We can help you find the answers to them. I'm just not sure that we're prepared, because we've never presented this topic before. But we did want to make sure that we got this information out during Fair Housing Month. So if you have submitted your questions in the questions box and we have not answered it either in a general way or in a specific way, we will get in touch with you directly. And again, if you have other questions, please feel free to contact us directly. Nathan, could you put up our contact information page?
Absolutely.
While we're wrapping up here? Thank you.
Yeah, and I do want to circle back because one of those questions does touch on something that we did answer earlier, and may have just been buried because it was right at the end of the presentation, beginning of questions. If you are not a recipient of HUD funding or USDA funding, or IRS funding, right? If you don't participate in any of these covered programs, you're just a landlord, a private landlord, market rate apartments. Does VAWA apply? Technically, no. VAWA is not required of you. But if you are a landlord who wants to support these protections and grant these protections to a covered person, absolutely, you will want to consider how you do that in your written policies and procedures, possibly in your lease, or possibly by creating a lease addendum. So, if you want to go above and beyond, that is awesome, and that is great. We're not going to necessarily be able to help you with what the rules may be. That's something you'll want to consult your attorneys on when you go through this process. But you're not barred from granting these protections if you're a private landlord.
Great, Nathan. Thank you for that clarification. So I think I'm going to stop us for today with these questions. Again, we'll get back with you. I see some questions that are coming in that we've covered a couple of times as well. I don't want to repeat multiple times. So again, thank you all so much for joining our presentation today. This was a new topic for us, so it was interesting to see the types of questions that came in. We got some real specific ones and some pretty broad ones. So, you know, the next time we do this presentation, it's very helpful to have your questions to wrap them in to get, you know, to be presented up front. So we really know what things need to be touched on again and again. So again, thank you so much for your participation. Send us all of your questions. We will reach back out to you. Join us next week for our other two Fair Housing Month training webinars on affirmative marketing and limited English proficiency. Again, this presentation, the slides, the handouts, and the transcript will all be posted on TDHCA's website. And if you attended today and you signed up, even if you registered and didn't attend, if there's someone else in your agency that wasn't able to make this presentation, if you registered, you will receive an email that has a link to all of this information. So again, thank you so much for joining us, and I am going to close the webinar. Have a wonderful afternoon.